Hello, this is the IPS Legal Solicitors Frequently Asked Questions and Answer program. My name is Primrose. I'm a solicitor and partner at IPS Legal Solicitors here in central London. On this program, we're going to try and answer some of the most frequently asked questions that we have received from people. If you have any questions that you'd like to ask us, please do send them through to the details that are appearing on the screen right now, and we'll do our best to try and deal with those questions on this program. So we'll move on quickly to the first question. Okay, so that is one of the frequently asked questions that we receive regularly from people. Okay, it's a very good question. If you are in the UK without leave to remain and you have a partner who is settled in the UK, you may be eligible to apply for leave to remain. However, there are requirements that you have to meet. It's not automatic to get status just because you have a partner who is in the UK if you have no leave to remain. Okay, some of the requirements are easy to meet, but there is one particular requirement that is a problem for many people. I'll just go through the requirements quickly. One of the requirements is that you must have been in that relationship for at least 2 years. You must have lived with your partner for at least 2 years if you're not married. If you're married, the 2-year cohabiting rule doesn't apply to you. But if you are not married, you have to have lived together for at least 2 years. The second requirement is that the relationship must be durable. It must be a committed relationship. It must be genuine and subsisting. You have to satisfy the Home Office that you are in a genuine relationship. The third requirement is that there must be insurmountable obstacles to family life with your partner continuing outside the UK. Now, that one is the most difficult requirement that a lot of people fail to satisfy. If you cannot satisfy the Home Office that there will be very significant difficulties to family life with your partner continuing outside the UK, your application is likely to fail. Now, what amounts to insurmountable obstacles? There is no actual definition of what amounts to insurmountable obstacles. Each case has to be considered on its own facts. So the Home Office will look at your personal circumstances, and the Home Office will also look at your partner's personal and family circumstances. So let's say, for instance, your partner has children or family in the UK, and it will be difficult for them to move their family outside the UK with them. Then you might just be able to satisfy the Home Office that there are insurmountable obstacles to family life continuing outside the UK. You do need to seek legal advice if you intend to apply, because a lot of the applications that people have been bringing to us after they are refused are usually refused just because of that one particular requirement. So applications have to be prepared very well in order to satisfy the Home Office that there are insurmountable obstacles to family life continuing outside the UK. Right, that is a very good question, and actually is also one of the frequently asked questions, and especially so in the last 2 years since 2014, a lot of people are seeing that their applications for British citizenship by naturalization are being refused under the good character requirement because of things that they have done or things that they've omitted to do. The Home Office has issued a detailed guidance. It's about 31 odd pages, which lists the factors that they will take into account when assessing an application for British citizenship. Now, a fine for a TV license is actually one of the factors that they will take into account. Yes, they take into account things like fines, cautions, warnings. They call these out-of-court disposals. So if you've had a case and you've been fined such as not paying your TV license, it is a factor that they are likely to take into account when they are assessing your good character when you apply for British citizenship by naturalization. So if you've been fined in the last 3 years, they might decide to refuse your application, okay, on that basis. I must say, however, that the Home Office are required to carry out a comprehensive assessment of your character before they refuse your application just because there is one negative factor. They have to take into account everything that you have done since you've been in the UK. So if your application is just refused just because of a fine, it is something that you might be able to challenge if you think it's unreasonable, taking into account all other factors that might be in your favor, because there the argument will be that their consideration is not taking into account other aspects of your character. So I would advise that if you apply and if you are refused just because of a fine and there are other factors that are in your favor, try and challenge that decision. There are procedures for challenging a Home Office decision in an application for British citizenship by naturalization. You might be able to apply for reconsideration. If that fails, you might be able to even go further in judicial review proceedings to the High Court. So I'm always advising people not to lose hope when they are refused, because the guidance has listed quite a number of factors. Apart from fines, they will take into account unpaid debts. They will take into account issues like a person being declared bankrupt. So there are a number of things. It's quite a prescriptive guidance, and I would advise people to seek legal advice before they put in applications, just in case there is something negative that will work against them when they apply, because your legal advisor will be able to give you advice on how you can try and convince the Home Office to exercise discretion in your favor, despite having that negative factor in your case. Because just having a fine or being bankrupt on its own does not necessarily mean that you are of bad character. And this is what the High Court has said in a number of cases that the High Court has considered. So do seek legal advice. Do not give up hope. If you feel you want to discuss this further, please do contact us at IPS Legal using the details that are appearing on the screen right now. And like I said, if you have any questions that you would like us to deal with, do email us those questions, and subscribe as well to AIL TV for these future programs. You can also follow us on Facebook and Twitter, and you can visit also our website at www.ipslegal.co.uk.